Let me tell you about an incredible story from the world of international law. It's a story where the fate of a nation really hinged on a team of scholars facing a task that was, well, pretty much impossible. It's a historical detective story, but with the highest stakes you can imagine. So here's the central question. How do you possibly win a legal battle when you're up against 300,000 pieces of evidence that are almost impossible to even read? This was the mind-boggling challenge facing India back in the 1950s, a question that would take them all the way to the world's highest court and deep into the dusty, decaying archives of a fallen empire.
So, to really get this, you have to understand the map. The whole conflict started with a geographical puzzle, a really strange leftover from the colonial era, still sitting there on the map of a newly independent nation.
Okay, picture this. You have two tiny pockets of Portuguese territory, right? They're called Dadra and Nagar-Aveli. But here's the catch. They are completely 100% surrounded by India, totally boxed in, no route to the ocean. The only way in or out was by crossing Indian land.
As you can probably guess, this was a recipe for high tensions. So in July 1954, India decided to restrict Portugal's access, especially for moving troops and weapons. And right after that, local activists saw their chance and completely overthrew Portuguese rule, just like that.
So what does Portugal do? They claimed their sovereignty was violated and took India straight to the top, to the International Court of Justice. Their demand was simple. They wanted the court to recognize their historic right of passage to get to these landlocked territories. And with that, the legal battle was officially on.
Now, Portugal's whole case was built on a treaty from the 18th century. So to fight back, India had to prove that historically this right of passage was never an absolute right at all. It was more of a courtesy, a matter of permission. And to prove that, they had to go to the archives.
300,000. Let that number sink in. That was the staggering figure India's legal team presented to the court, the estimated number of historical documents they had to dig through just to build their defense. A literal mountain of paper.
And look, this wasn't some wild exaggeration for the courtroom. This is a direct quote from a court filing in 1956. India's lawyers spelled out the enormous scale of their task, buried deep within the archives of the old Maratha Empire, known as the Peshwa Daftar.
And it wasn't just the sheer volume that made this an archival nightmare. I mean, can you even imagine trying to work with this stuff? Many documents were in Modi script, a really complex shorthand almost no one could read anymore. They were written in an archaic form of the Marathi language, but also mixed with Portuguese, Persian, and English. And to top it all off, they were scattered in archives all over the place, from New Delhi all the way to London.
And then there was the physical condition of the documents themselves. They were literally falling apart. As India's legal team wrote to the court, the paper was so delicate, and in many cases, the ink had bled right through to the other side, creating this jumbled, confusing mess of text. It was, as they put it, very troublesome to decipher. What an understatement.
This visual right here, it just captures the entire project perfectly, doesn't it? On one side, you have the raw material of history, faded, confusing, fragile, and on the other, the final product the court needs, a crisp, formal, clean legal argument. The monumental job was somehow turning the first thing into the second.
So, you're probably wondering, how on earth did this massive archival project affect the legal case itself? Well, when you're faced with a mountain of paper like that, India's team had really only one option: ask the court for more time. And then ask again and again. This timeline really shows you just how painstaking this whole process was. For over 3 years, India kept having to request extensions. They pointed to the huge research challenge, even noting that this was their first international case, and they just didn't have the trained people for a job this big. Finally, in February 1959, their main counterargument, a huge legal document called the rejoinder, was ready. So after all that digging, all those years of research, what did it all boil down to? Well, the fundamental disagreement was actually pretty simple. Portugal said, hey, we have a treaty from 1779 that gives us an absolute right to cross your land. And India countered, no such right ever existed. Any passage was always a courtesy, and it's always been subject to our control, our sovereignty.
But here's the thing. As the years of legal wrangling dragged on, the case started to morph into something much, much bigger than just old treaties. It became about the reality of the present.
You see, by the time this case was finally heard in the late 1950s, the facts on the ground in Dadra and Nagar-Aveli had totally transformed. That uprising back in '54, it wasn't just a temporary thing. A new, independent government run by the local people was now in charge.
And this change on the ground, it gave India a powerful new argument, one that went way beyond those dusty 18th century documents. They could now tell the court, look at the reality today. The people there are governing themselves. Forcing them back under colonial rule would be unjust, it would be met with desperate resistance, and it would threaten the stability of the entire region.
And just like that, the whole question for the judges had evolved. It wasn't just about interpreting an old piece of paper anymore. It was now about whether a historical claim from a colonial power could be used to turn back the clock and crush the will of a people who wanted to determine their own future.
And that's really the provocative question this incredible case leaves us with, isn't it? Where does the authority of law truly lie? Is it in the faded ink of centuries-old agreements, or is it in the living, breathing reality of a community shaping its own destiny?